The Companies Act aims to regulate fair competition practices in South Africa. As we know, the purpose primarily is for the Act to improve the economic efficiencies of companies by allowing consumers to enjoy lower prices and a variety of choices, of course. Now, it hasn't quite gone according to plan for some big construction companies. Let's find out why. I'm joined by legal expert Mr. Paul Coetser. Mr. Coetser, good morning to you. We are talking about this collusion with top building firms in South Africa. Is that because the Act wasn't quite clear on how big companies should conduct themselves?
No, I think the Competition Act is actually quite clear that any tender rigging or bid rigging for any contract, whether it's a public contract or a private contract, is a contravention of the Competition Act. So it was clear that if they engage in some form of cooperation amongst them to bid for those contracts, that would be a contravention of the Act.
What does the Act stipulate as far as any penalties or fines are concerned if they are found to have contravened parts of it?
Any of those companies can be fined up to 10% of their annual turnover for an offence.
With the companies that we are dealing with at the moment as well, are we talking a cooperation from the various companies, or are they some of them fighting it, to your knowledge?
2 years ago, the Competition Commission announced that there would be a fast-track settlement process for those companies that wanted to come forward and, so to speak, confess their sins. We understand that up to 18 companies have come forward and agreed to pay penalties, and it's in the process of settlement negotiations. If one comes forward, of course, you won't have such a large penalty, and we understand that it would be up to about 6% of those companies' turnover.
Well, is there any chance of personal liability? Is there any enactment of that in this Act for persons to be held accountable?
The Competition Act itself doesn't provide for personal liability. There is an Amendment Act that has not yet come into force that will make the actions of individuals also personally liable. However, in the case of tender collusion, there's also the Corruption Act that applies. And in these cases that we are talking about now, there are apparently some charges that have been laid at the Hawks, and the Hawks will be investigating whether individuals were personally involved and could then potentially face criminal penalties.
What were the loopholes here that were able to be exploited? I imagine that those in charge of, for example, the Act that deal with this collusion and tender fraud, for example, and the Corruption Act, as you mentioned, to come in into play later. What is now needs to be changed, in your opinion, to prevent something like this in future?
Well, the main important thing is from the company's perspective. They have to institute good compliance programs so that they cannot face these penalties. They have to educate their staff, their top management needs to be aware of the Competition Act, and they need to know their obligations. So training is very important. However, I think the Act is quite clear that you cannot get involved in it, and maybe going forward, the companies to whom the tenders are made will be much more circumspect, and they will ask declarations and check first whether there were collusion before the tender is awarded.
So this wasn't a loophole somewhere in an Act. This was a simple breach of what the law talks about.
Correct. And the difficulty, of course, is that collusion and bid rigging takes place outside the public view in dark rooms somewhere, and so it's very difficult to detect. But I think going forward, the public companies will make sure that there are declarations that the companies have not been involved in tenders, and perhaps do a little bit of investigation before awarding the tender.
We are talking about, as a final question to you, Mr. Coetser, we know the chance of penalties and fines is quite high. Is it a maximum of 10%, or could those argue who are arguing against these companies, could they ask for a more severe punishment? What is the maximum they could face?
Well, it's 10% per offence. So it's for each project that they have been involved in, and we understand that there are up to 60 projects here that people have talked about settlement. So the fines can be humongous.
We'll wait to see. A huge pleasure in having you in this morning. Thank you very much for your clarity, your perspective. Legal expert Mr. Paul Coetser with us on Morning News Today.
News that moves. eNCA.com.